Good morning, everyone. Today is Monday, December 18th. Snowing quite profusely outside. It's 5:30 in California. I'll let this run for just a minute. We've got a pretty busy morning. We've got a pretrial at 8:30, 9, 9:30, 10. And we've got two 10:30 sentences and 11 o'clock sentence. We have a meeting, a bar meeting at lunch. Then we pick up again at 1:15 with a pretty busy landlord, 10 a docket, then about 6 small claims cases. So it's going to be a full day. And but that makes the day go faster. I think I'm going to live through this cold. I'm on about day 12 of it. But I think I'm on the backside. Thank you all also for the nice cards and other things. Our first matter is just a general civil pretrial. Well, we've got a lot of time zones from Washington and California to England to Tennessee to Sweden. So thank you all for saying good morning. Some of you were up earlier than others. And good morning, Liverpool. Good morning, South Bend. Good morning, Victorville. Let's see if we've got any customers in here. Two minutes. We had an issue last Monday with Express Auto. No one appeared for the plaintiff, and I wasn't able to reach anyone. Our first matter is entitled Express Auto versus Terrence Davis. Whoa. A couple of visitors just came in who emailed about 2 minutes ago, must have been from the parking lot. If I lived in California, I wouldn't want to come to Michigan on December 18th, but you just never can tell. So we're in here doing a bunch of nothing right now, but that's somehow how it goes. I'll let this run a little bit in case people do come in. That's one of the issues with Zoom is the judge, at least here, because I don't have a clerk that does this. Many judges have clerks that do it. I have to be in here and sit here in case people show up. So I end up sitting in this chair rather than in my office more than I used to. I have to say I am very surprised. Didn't expect to see our visitors at Christmas time because it is particularly crappy right now. We've had a very mild December, but it's snowing pretty good right now. Well, as I mentioned, no one showed up from Express Auto last week and no one's here today, but the defendant isn't here either. So maybe they worked something out. I'll let this run till about 8:35, then I'll turn it off. And this can't be much more boring than this, sitting here watching me sitting here. All right, I'm gonna shut this off, the live feed and the record. I'll still be here, but see if anybody shows up. If they do, we have another 9, we have 2 at 9. So we will be back shortly, but I have a feeling that no one's gonna be here for this one. Maybe get up and come in early, 7:15 hour this morning. And at least I think we'll get some business taken care of before the end of the year. It's always good to close some of these files out in the calendar year.
That's a lot of cases.
You're still first in line. Maybe that's because you're the shortest distance. And it's not 5:30 either. All right, let's go ahead and good morning once again, everyone. All right, it's 9:01. The matter before the court at this time is Discover Bank versus Randy Clark. The file number is 23813GC. Attorney Jeffrey Bears is here on behalf of Discover Bank. Randy Clark is not here. He is represented by attorney Diane Zagararis, who does a lot of defender work in collection cases. We've been here at least twice before. September 18th, we were here. There was discussion that he had been in contact with the debt settlement company, National Debt Relief. We continued the matter until October 23rd. On October 23rd, Mr. Bears was here once again. And we were ready to do a default in the amount of $2,884.73, and plaintiff's counsel arrived late, which she's only 2 minutes late here this morning, so we'll bring her in. And so the matter was continued until this date for a motion for summary disposition. Good morning.
Good morning.
This is Judge Middleton. I'm here at the court in Centerville. Mr. Bears is here on behalf of his client, Discover Bank. You're here on behalf of your client, Randy Clark. We have a full gallery here in the courtroom, and we're working on some general civil pretrials, one at a time. This matter, as I mentioned just a moment ago, was set for September 18th and October 23rd, adjourned to this date. Plaintiff has filed a motion for summary disposition, and the matter is scheduled for hearing on that this morning. There were some efforts at debt consolidation through National Debt Relief. I'm not sure what the status is here this morning. So, Mr. Bears, let me defer to you first.
May it please the court, Your Honor, Jeffrey Beers, P 41693 on behalf of plaintiff Discover Bank. This is plaintiff's motion for summary disposition arising from a default on a credit card. There's been no written response to our motion or affidavit or documentary evidence filed by the defendant to rebut our exhibits. Therefore, our motion is unopposed. MCR 2.116G4 requires a written response. Otherwise, judgment shall enter against the defendant. As our motion is unopposed, we ask that it be granted and that judgment enter in the amount of $2,904.73, which is composed of damages of $2,734.26 for a cost of $170.47 for a total amount of $2,904.73.
Ms. Zagararis, what's your position?
Mr. Bear's restatement of the issues is correct. And at this time, we are willing to concur with entry of the motion for summary judgment order.
I don't have an order here, I don't think.
It's at the way bottom.
I have a default order, but not a summary disposition order, and the numbers are different. All right. Defendant concurs or accepts. I guess then you can continue to discuss consolidated settlement.
Our proposed order is at the very bottom of the stack of the exhibits. The very bottom.
All right.
Of this. There's a proof of
I
service.
didn't dig far enough.
One page from the proof of service. That's the order.
Proof of service order. Oh, it was right where you said it would be. It is very helpful to have the order here, so I appreciate that. All right. Defendant acknowledges the motion. There was no answer, accepts the entry of the order. $2,904.73. Now, this is now a judgment rather than a complaint, and it can be added to whatever debt they're attempting to consolidate. Otherwise, plaintiff can pursue collection remedies. So I've signed the order. Is there anything else we need to do?
Thank you, Your Honor, and have a good day.
All right, and I won't see either of you again before Christmas, so have a good holiday, and Zoom is a wonderful thing for cases like this. All right. It isn't good for every case. I've certainly had some that didn't work out so well, but it's perfect for this sort of thing. So thank you very much, both of you.
Thank you.
Thank you, Judge.
See you next year.
Yep.
All right. All right, we are back. And Colleen's always one or two. Good morning. We've got some other general civil pretrials. I'll probably be turning this on and off all morning. Next matter is set for 9:30. Had some struggles in this case. In this particular case, it's entitled J.P. Morgan Chase Bank versus Holly Myers. We've never had both sides here at the same place at the same time. Let's see if we can accomplish that this morning. Good morning.
Good morning.
You're here right on time. We've got to see anyone for J.P. Morgan Chase. So we'll let the clock tick here a little bit.
Okay.
Here's Attorney Royce.
you, Your Honor.
Good morning. This is JP Morgan Chase Bank versus Holly Myers. The file number is 23897GC. Mr. Christopher Royce is here on behalf of JP Morgan Chase Bank. And Holly Myers is in pro per. This is the first time we've ever actually had both sides here at the same time. We had a hearing in September, and Miss Myers was here, and the plaintiff didn't show up. There was some discussion that the original attorney had left the firm, and I'm not sure exactly what happened. So the plaintiff moved to set aside the motion dismissing the case, and that was heard on October 27th. At that time, Mr. Royce was here, but Miss Myers was not. So I set the dismissal aside and reinstated the case. So we've had now our third hearing to try to accomplish something. The claim, as I indicated, is for $4,448.72. Miss Myers did file an answer, which was a general denial. And it took us a couple of hearings to get to this point, but at least we have both parties here. Mr. Royce, have you had any discussion with the defendant?
I have not. I would be happy if we want to put us in a breakout room, or, well, at your pleasure, Your Honor.
All right, thank you. Ms. Myers, are you willing to talk privately in a breakout room with Mr. Royce about the case and see if you can make some progress on a resolution?
Yeah, absolutely.
All right, that's what we would have done the first time or the second time, but we couldn't get everybody all here at the same place at the same time. So let me open a breakout room. A little button will come up to say join.
Okay.
You click on that and I will wait here while you guys talk.
Thank you.
Welcome back. Mr. Royce, were you able to make any progress?
Yeah, I think actually, I'm very much encouraged. I think that maybe, with the holidays, maybe we could have 45 days. And then hopefully she just gave me her email. I'm going to email her contact information, and she made an offer that I will submit, and I think we'll continue our discussions, and I'm very hopeful.
You agree with that, Ms. Myers?
Yes, I do.
All right, we do have time guidelines. This case has been bumped twice, but the world isn't going to come to an end if we push this out a little bit. Which would take us to February the 19th is President's Day, I believe. So can we continue this to February 26th?
Okay, that's fine.
Yep, that works for me.
2024. I have to get used to writing that at 9:30. Parties will continue to work on settlement. All right, very good. Is there anything else we should put on the record here?
My perspective, Your Honor.
All right, Ms. Myers, you okay too?
Yes, I am.
All right, I'll see you in February by Zoom. And of course, if the matter is resolved, you can submit a judgment or a consent order, and we won't need to appear at all. But if it is not, we will be here on that day.
Great.
All right.
Thank you, Your Honor. Have a great
Thank
day.
you.
Thank you.